Hi everybody, Dana Sparks, broker of Maximum One Greater Atlanta Realtors, and today's contract tip has to do with parties that are binding on the RE forms contract and elect a closing attorney to be the holder of the earnest money. How do you as an agent go about protecting the buyer and the seller in that situation? So, let me give a little bit of background and then I will get into the specifics. So, for whatever reason, there are buyers and sellers that are choosing to have a closing attorney as the holder of the earnest money rather than one of the brokers, the buyer's broker or the seller's broker. And I have a lot of videos on that topic and a lot of issues regarding that. And I'll link some of those videos below. But go to the search feature, the little magnifying glass feature in the YouTube channel and put in attorney as holder of earnest money. Or you can click on the playlist and look under all the earnest money videos and you'll find all those videos there. But nevertheless, think about it. If you put down the closing attorney as the holder of the earnest money, then generally speaking, what happens is you as the agent describe to your buyer, when you're the buyer's agent, that your earnest money is protected with all these contingencies. If you terminate based on one of the contingencies within the time frame and send notice within the time frame, you'll get your earnest money back. Or you tell the seller, let's ask for this much earnest money. If the buyer defaults, the remedy for that buyer's default will be the earnest money that you will get as liquidated damages to, for the time that the property was off the market to work with this buyer, so forth and so on. So, and you say, the holder puts the money in the trust account and we'll know if it gets deposited. We'll know if they never send it. And, if something terminates, there will be the holder that will do the interpretation of the contract and so forth and so on. So why are you telling your buyers and your sellers this? Well, you tell your buyers and your sellers this when one of the brokers holds the earnest money, because when you as the affiliated licensee, you are affiliated with your broker. When you come on board with a broker, your broker gives you permission to sign contracts in their name. And when you sign that contract, part of what the broker agrees to is if the broker is named as the holder of the earnest money, then the holder agrees to fulfill all the responsibilities as holder of the earnest money, all the duties and responsibilities, and follow the processes and procedures as outlined in the contract. So that's what happens when you as an affiliate licensee with your broker sign and the broker is the holder of the earnest money. So, and all of these processes and procedures are outlined in the purchase and sale agreements. They are in the GAR forms, it's in the purchase and sale agreement 201, and in the RE forms, it is in the standard terms RE1. So that's where you got all this information, that the holder is responsible for sending notice if the buyer never sends the money, if the earnest money is not honored by the bank, because then there's potential termination rights for a seller. The holder has a duty to deposit it once it's received. Should there be a termination and not agreement by the buyer and the seller regarding the disbursement of those funds, one of the options available to the holder is, as outlined in the contract, is to interpret the contract, interpret what happened, why did it fail to close, was the termination based on an unexpired contingency, was the termination by default, who's entitled to the earnest money, so forth and so on. And if it is too much money or too legally complicated, the holder also has the option to interplead those funds into a court, initiate a lawsuit and between the buyer and the seller over the disbursement of those funds, and a judge will decide and the holder gets to take their fees out of the earnest money. So all of that is explained in the purchase and sale agreements in both the GAR and the RE forms. And that's where you guys as agents are getting this information to explain the earnest money to your buyers and to your sellers, okay? Now, what happens if a closing attorney is labeled in the contract and agreed upon by the buyer and the seller as the holder of these trust funds, the earnest money? So you intuitively, and your buyers and sellers intuitively think that all of that I just went over and all of that you explain per the contract to your clients is going to happen. But let me ask you a question. Where in the purchase and sale agreement does the closing attorney sign agreeing to be the holder, to fulfill all of those responsibilities as outlined in that contract that you explain and set the expectations with your buyers and your sellers? Nowhere in the purchase and sale agreement does the closing attorney sign and agree to any of that. So for all intents and purposes, your buyers are just writing a check or giving certified funds or wiring thousands and thousands of dollars to a closing attorney with no corresponding paperwork. There's no receipt for the funds. I mean, it has it in the purchase and sale agreement, but the closing attorney doesn't sign the purchase and sale agreement. They don't agree to that. They don't agree to do any of that. And yet you're having your buyers give them thousands of dollars. Now, don't get me wrong. Your closing attorneys can't steal the money. But if they don't sign agreeing to fulfill all of those responsibilities and processes and procedures outlined in the contract, they can do anything with that money that they want. And what I mean by that is they don't ever have to deposit it. If they never get it or it's not honored by the bank, they have no obligation to let the buyer or the seller or the agents know. And if there's a termination, closing attorney can give it back to, can disperse those funds to whomever they want. There have been times in the past where a closing attorney dispersed the funds, returned the earnest money back to a buyer, even upon a clear buyer default. And the closing attorney stated that that's who gave me the funds, that's who I'm returning them to. Any contract dispute is between the buyer and the seller. I'm not a party to the contract. I didn't sign anything agreeing to do any of that is outlined in the contract. A lot of closing attorneys won't even accept earnest money. So a lot of issues are at stake, or a lot of issues to think through when you choose a closing attorney as the holder of the earnest money. Now, in the GAR forms, GAR, Georgia Association of Realtors, has addressed this issue by adding 2 additional forms. There is one form that is an agreement. It's GAR F510. It is an exhibit to the purchase and sale agreement where the buyer and the seller agree that this is the closing attorney that's going to hold the earnest money. These are all the outline. This is outlined what has to happen. Buyer has to get the contract and the funds to the earnest to the closing attorney within 3 business days. If not, the alternate holder becomes a holder, so forth and so on. And that is an exhibit to the contract that is signed by the buyer and the seller. And like I said, there is a place in that exhibit where if the closing attorney does not agree to be the holder within the time frame specified on that exhibit or flat out refuses, then the alternate holder automatically becomes the holder of the earnest money. Then there is a corresponding form, F511, that is not a part of the contract. It's not an exhibit. It is a separate agreement signed by the closing attorney where the closing attorney agrees to fulfill all the responsibilities of the holder of the earnest money as outlined in the purchase and sale agreement. They have to sign this within a time frame, so forth and so on. So GAR has addressed this issue by creating the 2 forms. One, that where the buyer and the seller agree everything that has to happen if the closing attorney is holding the earnest money. And then a separate agreement just between the signed by the closing attorney agreeing to fulfill all those responsibilities of holder as outlined in the purchase and sale agreement. Now, just parenthetically speaking, while we're here, if the closing attorney does not timely sign that document or never signs that document, then the alternate holder, which must be either the seller's broker or the buyer's broker, and if that is left blank, it automatically defaults to the buyer's broker. That broker, if they never get the earnest money, should send notice to the parties that there's no earnest money received. So that's just a whole nother topic of discussion. All right, so now, what if the buyer and the seller go binding on the RE forms contract, or for that matter, any other contract other than GAR? Let's say it is a new construction contract, a HUD contract, Fannie Mae, Freddie Mac addendum that overrides, that would supersede some of the terms of the purchase and sale agreement, an attorney written contract, an investor written contract. Hang on, I dropped my glasses. So this is not, none of those contracts have a place for the closing attorney to sign either if the closing attorney is agreed upon and negotiated by the buyer and the seller to hold the earnest money. But back to the RE forms. So if the buyer and the seller are binding on the RE forms, and for whatever reason they choose to have the closing attorney as the holder of the earnest money. And again, this is a discussion, you guys, to have with your clients. Your closing attorneys, their specialty is closing transactions. And your buyers and sellers think, ooh, it's an attorney. In the event of a dispute, there's going to be some quote-unquote legal recourse. No, your closing attorneys are closing attorneys. Some of them absolutely will do an amazing job, understand the contracts, will interpret the contract, so forth and so on. But some of them, that's not their specialty. Your brokers, for the most part, I know at maximum one, our brokers are extremely well educated and well versed in the GAR and the RE forms purchase and sale agreements, and do an amazing job should there be a dispute over the disbursement of the earnest money upon a termination. But generally speaking, your brokers, all brokers, have more day-to-day experience with the contracts, with the ins and outs of the contracts. So just a discussion to have with your clients. Also, you need to check with the closing attorney. There are a number of closing attorneys that absolutely do not want to hold these escrow funds, and there are some where they will not hold those escrow funds because it's a potential conflict of interest with one of the parties. It's the amount isn't something that they're going to agree to. They won't sign the form until they get the earnest money, so forth and so on. So there's a whole lot of issues going on. But back to the point. So if the parties are binding on the RE forms contract and they negotiate to have a closing attorney as the holder of the earnest money, the RE forms does not have any specific form like GAR does addressing this specific issue. So what do? Well, if you don't have the closing attorney sign anything, then just like I said, your buyers are giving these attorneys thousands and thousands of dollars with nothing in writing about what happens to it. So the RE forms does have an escrow agreement. And in that form, the escrow agent, which in this case would be the closing attorney, does sign. But the escrow agreement in the RE forms is really designed for additional escrow money, not specifically earnest money. Nevertheless, this would be one option. As a broker, I strongly suggest you do get the closing attorney to sign something stating that they do agree to fulfill those responsibilities and follow the processes as outlined in the contract regarding the earnest money, so that you can have a meaningful conversation with your buyers and your sellers regarding what happens with those funds. So let's look at this a little bit closer. I also want to let you know that the GAR forms also has an escrow agreement, and in GAR it is 513. And again, these escrow agreements really are designed for other funds being escrowed. For example, if the parties choose to escrow money for repairs, to make sure repairs are done, or something along those lines. But nevertheless, with respect to the RE forms, this would be a good form to use if the closing attorney is the holder of the earnest money. So in the RE forms, it's RE 215, and it's called Escrow of Funds Agreement. And again, it's not an exhibit to the purchase and sale agreement, because the buyer, it's just an agreement. The buyer and the seller do sign it, and the closing attorney signs it, which is why it would be appropriate if you add something. So it has the date, it has the property address, it references the contract. It basically states that with respect to the contract, there are going to be funds that are escrowed. It has a place to fill in the amount, and the escrow holder is named. Now, then it goes on to say, there's one paragraph, number 2, conditions, and that's where we're going to come back to. Then it comes back, and there's a paragraph about the buyer's lender. The buyer's lender must approve if there is a loan involved. And again, it does name the escrow holder. And then it has a whole section regarding the disbursement of the escrow funds based upon the conditions being met. Then it has a section on the escrow holder's duties. And it says specifically in this RE form, the escrow holder is not bound in any way by any contract between the buyer and the seller. The only duty, liability, or responsibility of the escrow holder shall be to hold the escrow funds. This does not in any way limit any duty that the escrow holder may have when acting in a capacity other than as escrow holder. In other words, if it's the closing attorney or even one of the brokers. In performing any of its duties hereunder, the escrow holder shall not incur any liability to anyone for any damages, losses, or expenses, except for fraud or breach of trust, and it shall accordingly and not incur any liability with respect to any actions taken or omitted in good faith to the duties and responsibilities of escrow holder under this or in this escrow agreement. It goes on to say basically that. Then it talks about disputes. Regarding a dispute, it states, the escrow holder exercising its discretion shall be entitled to the lender into the registry of any, shall be entitled to tender into the registry of any court of competent jurisdiction the escrow funds and escrow documents together with such legal pleadings as it may deem appropriate, if a dispute arises between the buyer and the seller in connection with the escrow funds. Thereafter, the escrow holder shall be discharged from all further duties and liabilities under this escrow agreement. Any such legal action may be brought in such court as the escrow holder shall determine to have jurisdiction thereof. Then it goes on with some more indemnification clauses, some more information. Then there is a place that the buyer signs, the seller signs, and the escrow holder signs. So this form in and of itself, basically, number 1, does not address the escrow funds as earnest money, as earnest money is handled and addressed in the purchase and sale agreement. It's just talking about escrow funds. Number 2, if it doesn't obligate the closing attorney, as we've talked about, to fulfill any of those responsibilities of the holder as outlined in the purchase and sale agreement. It merely says that the escrow agent, the closing attorney, would hold the funds and then disperse them, and if there's a dispute, they have the right to interplead them into a court should they deem that necessary. So what you can do to make this a little bit more appropriate as a form to use to have the closing attorney sign and fulfill, make sure your buyer and your seller understand that what happens to the earnest money with respect to how it's all outlined in the contract. You would have to add under that paragraph 2, under conditions, some sort of stipulation that ties all of that in. So, and let me even before I do that, let me tell you that just because a contract describes the contingencies and default and timeframes and forms of notice, in order for any holder of the earnest money to disperse those funds, we must have signed agreement by the buyer and the seller directing us how to disperse those funds. If not, and that is not only described in the contract. If not, then there are other things described in the contract what can happen. But that is also part of license law. And under GREC Rule 520-1-.083B, number 4, where the license law regarding handling of escrow funds, it does say that the broker, because again, license law is not incumbent upon closing attorneys unless they hold a real estate license. This is license law for somebody holding a real estate license, and your brokers hold a real estate license. So it says that the holder of the earnest money as a broker may disperse those funds upon receiving a written agreement signed by all parties having an interest in those funds, that would be the buyer and the seller, separate from the contract that directed the broker to hold those funds. So you must have a signed release part of the TNR in order to disperse those funds. All right, so back to this escrow agreement in the RE forms. If you are not a Maximum One agent and you are watching this, please run any special stipulations by your broker prior to using them. But one special stipulation to tie all of this in together would be, and I'll type this verbiage below as well, all parties acknowledge that the funds referenced in this escrow agreement refer to the earnest money per paragraph 3 of the contract for purchase and sale of residential real property in Georgia and paragraph 3 of the standard terms for the purchase and sale of Georgia real property. The escrow holder shall fulfill all the responsibilities as holder of these funds as outlined in those paragraphs of the contract referenced herein. So, you like that? If you add that under the conditions, paragraph 2 of this RE Forms escrow agreement, and the closing attorney signs it, then that does, in essence, tie in the closing attorney's response as holder of the earnest money. Number one, it references those funds as earnest money versus another escrow deposit. Number two, it ties in everything regarding the disbursement of the everything about earnest money, including making the deposit, notifying the parties if they never receive it or if the bank doesn't honor it, dispersing it upon a closing as outlined in the purchase and sale agreement, and how they can different options available to them should the contract not close, and they either they get a signed TNR and they disperse based on that, or they have other options to them should the contract terminate and the buyer and the seller not sign and agree upon the release of the earnest money. That would now obligate the closing attorney as the escrow holder to fulfill all of those, to be able to interpret the contract, send out the 10-day letter, or they still have the option to interplead those funds. So I hope this contract tip helped you out, and just make sure to have a discussion with your broker prior to using any special stipulations that you hear in this video or any video, and have a really good discussion with the buyer and the seller as to the holder of the earnest money. And if for whatever reason they do decide to have the closing attorney as the holder, you best make sure that the closing attorney agrees before this all happens. If not, you will need to make either the seller's broker or the buyer's broker the holder of the earnest money. And I think that's it. Thank you guys so much for watching. Dana Sparks, broker of Maximum One Greater Atlanta Realtors, satisfying your needs with service, innovation, and education.